Matter of NYP Holdings versus New York Police Department.
May it please the court, my name is Matthew Daly for the PBA of the City of New York. May I please reserve 4 minutes for rebuttal?
Yes.
We're asking the court to hold that the repeal of Civil Rights Law Section 50A was not retroactive. The key mistake that the First Department made was it swept away more than 4 decades of pre-existing statutory rights by labeling the repeal as remedial. The remedial label does not fit in this case, where the legislature made a complete 180-degree policy reversal by reversing Section 50A after more than 40 years.
Who did the rights belong to? That's my question.
The rights belong to the police officers, or the covered employees, police officers, firefighters, corrections officers. That's actually what the First Department held in this case in allowing the PBA to have standing to make the Section 50A argument. That's the law of the case. It hasn't been, that aspect of the holding hasn't been repealed or hasn't been appealed, but we were also very solid on the law on that point, that this right belonged to the officers.
Can I ask you to start not with the application of the retroactivity analysis, but whether or not there is something retroactive, and maybe you can explain how this is, why this isn't controlled by Acevedo and Forti?
Yes, so this is the alternative argument that the respondent makes, that there's no retroactivity analysis required. And as the court knows, the Second and Fourth Departments accepted that argument. We submit it's wrong for several reasons. Number one, and you don't really need to go any farther than this, General Construction Law, Section 93. Second Department didn't address this. Fourth Department didn't address this at all. What that statute says is it creates a presumption that the repeal of a statute does not affect rights that already accrued, and those rights may be enjoyed and enforced to the same extent as if such repeal had not been affected.
So if we think, though, that that doesn't control, how do you address those cases?
I would disagree that it doesn't control, but we're
that.
still within a retroactivity analysis under the common law, Your Honor. So I'll distinguish Acevedo and Forti in just a moment, but I think the starting point is even putting aside the general construction law, and I don't even think it's disputed by the respondent that the general construction law applies here. There's no argument why it wouldn't apply to a statutory repeal like this. But so what's the standard under the common law for retroactive effect? The court set this forth in Regina Metropolitan and even just last November in the Jeter versus Poole case. Whether the change in the law would impair rights a party possessed when he acted, increase a party's liability for past conduct, or impose new duties with respect to transactions already completed. This case falls within the first bucket of that test, impair rights a party possessed when he acted. So what Section 50A said is, at the moment a police or covered employee personnel record was created, it shall be confidential and was exempt from production in all contexts, not just FOIL. The right attached as soon as the record was created. So it's not like a situation where the officer had to commence some sort of proceeding in order to get the benefit of Section 50A.
But how come, I take it this is your vested right argument, yes?
Well, that's correct, Your Honor.
And so how come it's a vested right as opposed to an expectation that was created by the statute? I think we've distinguished between them. So
the definition of a vested right that we would ask the court to accept, and this is also set forth in the, let's see. In the Frontier Insurance case, they had a good discussion of this. It's a court of claims case, but it was affirmed in relevant part by the Third Department and then affirmed by this court. But the reason that this is a vested right is it's not a right that exists solely because no statute prohibits it. What we have here is an independent statute. It's actually the Civil Rights Law of New York State. The title of the provision is right to privacy.
Why couldn't it be thought of instead as a statutory privilege or an exemption? I think that distinction lies in our cases.
It's not a statute. So what we're dealing with here is an affirmative right granted by statute. And the second reason why—
That's what we're debating, I think.
Well, I think there's 2 parts to the vested right. Number one, I think it's an affirmative grant of a right. And then number 2, did anything else have to happen for this right to attach, which is the traditional notion of vested? Had it vested yet? And for purposes of Section 50A, the right of the police officer vested, as I was saying, the moment that the record was created. So when you look at the Forti case and the Acevedo case, and I would submit other cases where the court has applied this, what I call the future transactions doctrine, what those cases deal with are things like when somebody is applying for an employment position, when somebody is applying for a license or a restriction on future employment. In those cases, the courts say, okay, it's okay to look in the past. So the Acevedo case, people that had their licenses revoked for drunk driving, the commissioner has discretion whether to give them their licenses back. They reapply for their licenses. Of course, the commissioner can look back at their histories, and that's not a retroactive effect. What those cases don't involve is a statute that grants affirmative statutory rights. Those cases also do not involve General Construction Law, Section 93. The other, I think...
General Construction Law 93 is just an aid to construing statutes. Would you agree with that?
That's correct. And so that's why it's relevant to the question of whether or not there's a retroactivity analysis required at all. We're not saying that general construction law can never be overcome, but it's the trigger.
You're not saying that it provides any substantive rights either or anything like that. It's just an aid to construing statutes.
Well, it triggers a presumption that the pre-existing rights continue. So it triggers a retroactivity analysis. I don't see how you could avoid. Yeah.
I thought, though, it was really a canon of statutory construction that's codified. Are you suggesting that it creates some, when you say a presumption that is akin to a right, or simply a presumption in terms of how we would properly read the words of a statute?
I think it gives the court, it's a statute. It's just like FOIL is a statute that sets forth the policies of the state. The general construction law is a statute,
Well,
and it gives the court guidance. I don't think the court could say, well, I'm not going to even consider general construction law, or I'm not going to follow
I didn't mean to suggest that. Let me try to ask the question more clearly. It seems to me, as I read the provision, that it is a statute for sure that provides guidance in how we understand the words in some other statute. But that's very different than a statute that would give rise to something enforceable. It's to help us understand how to read the words that the legislature has written in other statutes and therefore decipher what their intent is.
I think it's a little bit stronger than that, Your Honor. What the statute says is the repeal of a statute or parts thereof shall not affect, and then it goes on. That's what I read that as mandatory language on the courts.
Sorry, go ahead.
No. The preface to that is it's a presumption. So is it your position it's an irrebuttable presumption?
Not at all, Your Honors. I'm solely addressing the question about whether or not we need a retroactivity analysis. When that presumption applies, then the next step is, has the presumption been overcome? And that's when you get into the question of, is there a clear expression of legislative intent to overcome the presumption?
So we said, I think, in Roper, which is almost 100 years ago, that it's a principle of construction to be applied in determining the scope of legislation. And so you look to whether there's, some evidence of contrary intent, but I think we said in Roper explicitly that it's a principle of statutory construction.
Your Honor, we might be on the same page. I'm not sure
Maybe
we're saying
it's a
something
question of
different.
Counsel, I think the problem is you said that 93 creates the right or something along those lines, and that's not what 93 says. 93 says that any right that existed at the time that the amendment went into effect won't be affected by the amendment, which is, it's not creating a new right, it's protecting a right that existed. And by the way, I happen to agree that in this context, because it appears in the general construction law, it's just a guide to judges and other people who are interested on how to interpret these kinds of enactments.
I agree with the first part that you said, that it's not the source of the right. The source of the right is Civil Rights Law, Section 50A, but that combined with the general construction law, I think disposes of my friend's argument that, well, now that Section 50A has been repealed, there's no longer an exemption under FOIL, records have to be produced. That argument doesn't fly because the general construction law and the common law says those pre-existing.
Kelly v. State sort of cuts against that. It involves, it's our affirmance of the appellate division on the decision below, in a case involving, it used to be that inmates could not sue while they were incarcerated, and they had a 2-year window to sue afterwards. And an inmate who was released sued within 2 years of release, but while he was incarcerated, the law had changed, allowing inmates to sue, and he claimed that he had a right to sue within 2 years of his release, and we acknowledged general construction law, well, the appellate division did, 93, and said, nevertheless, this does not establish a right.
Was that case in the briefing, Your Honor?
I don't believe so.
Okay.
But it's in the,
body of law.
yes,
The
New York
case-
reports.
The case I'll direct Your Honors to that we cited in our reply on this point is 850 Co. versus Schwartz, 15 New York 2nd, 899 from 1965. The court hasn't had occasion to address Section 93 of the general construction law too often, but in that case, the court enforced a statute after the statute had expired, and the court relied on general construction law to do that. But I want to get to, I think, we don't need the general construction law to win our argument here, because again, the common law doctrine of retroactivity also supports this. And what I didn't get to that distinguishes this case from the cases cited by my friend here is that the reliance interest on this independent right, we're not just talking about some abstract right here. This is a right that affected behavior. These disciplinary proceedings would have been different if Civil Rights Law Section 58 had not been effective.
Where in the record would we find that?
Yeah, so,
Other than just argumentation, where?
no, it's in our sworn, it's in our sworn pleading. It's in the record at page 322. This is a sworn answer that made the point that I just made. And what we said is reliance on the rights to confidentiality certainly impacted police officer decision-making in response.
Sorry, that's an affidavit from a police officer?
It's the equivalent of an affidavit. It's a sworn pleading, Your Honor, a verified answer. The other point I'll make about that is no court to have addressed this issue, the trial courts, the majority of which have ruled in our favor on this issue, the appellate divisions, no court has disputed that this reliance existed.
Counsel, can you just very quickly explain to me before you go, because your light is on, why is this not just an expectation that's been altered and is actually a right?
It comes back to the point that this is, I think the distinction that the law draws is between an expectation just because no law prohibits me from doing something versus when there's a statute that says, this is going to be the case. I'm giving you this right. And there's reliance on that right. It affects behavior. The right had vested. And I'll just remind this court of its 2018 decision in New York Civil Liberties Union, how this court characterized the rights under the Civil Rights Law, Section 50A, a guarantee of confidentiality, a promise of confidentiality. It provides the exclusive means for disclosure of confidential personnel records. So this is not a FOIL issue. 50A applies in all sorts of contexts, civil discovery, criminal discovery. It prevented agencies from just turning over this information. It was a right that belonged to police officers. So this was a very powerful right, and I don't think there's any case that this court has addressed or that's been cited in the pleadings where you have an affirmative right like this that's then repealed, triggers general construction law, triggers the common law, and to say that there's no retroactivity analysis required, I don't think that's supported under any of the court's precedents. I'll reserve my time for rebuttal.
Thank you.
Good afternoon. May it please the court, my name is Jeremy Chase from Davis Wright Tremaine, and I represent petitioners NYP Holdings, Inc., and Craig McCarthy. In June, this case concerns whether pre-repeal disciplinary records must be disclosed in response to post-repeal FOIL
You
requests.
want to maybe respond to your adversary's argument about vested right versus expectation?
Yes, this is clearly an expectation based on pre-existing law. The whole idea of this being a vested right is a bit it's a bit of a stretch.
Well, the statute did provide for release only upon court order or the express written consent of the officer, right?
Yes.
And so why didn't that latter provision give rise to a vested right? Which I take it is the crux of their argument.
Why didn't 50A constitute a vested right, is what you're asking?
Confer a vested right such that we need to apply the retroactivity analysis, yes.
Yes. So, first of all, the Landgraf case by the U.S. Supreme Court, for example, it emphasized that retroactivity deals with whether new legal consequences to an event
But I
attached to an
guess
event.
I'm asking under our case law.
Yes.
About what constitutes a vested right. Why is this not a vested right that was conferred by the prior statute?
I mean, I would ask when the right vested at all. I mean, my colleague,
Then you agree it's a right, it's just not a vested right?
when it was still in,
Counsel makes a
actual-
fairly good argument that in a situation like this, where the statute in question says XYZ shall be confidential, XYZ becomes confidential the moment it's created. So I don't want to put words in his mouth, but I think his argument would be the right vests at the moment of creation of the document in question.
I would say under the pre-existing law, when 50A was an extant law, I would say that it certainly was a right that belonged to the police officers.
But
or-
if you're conceding that it was a vested right, then I think the question becomes, first of all, when did the right accrue? When would the right have accrued? At the time I assumed that the record was created. And then I think we're in the box of applying the retroactivity analysis. But I thought you argued to us that we need not do that.
Well, Your Honor, I'm not saying that it is a vested right. I'm saying that it was a right, certainly, that belonged, but qualifying it as a vested right, I don't think that's accurate.
So why is it not a vested right such that we need to consider whether or not the repeal is retroactive?
Well, Your Honor, first of all, let me, give me 1 moment, please. There's no, as I mentioned before, so there's no legal consequences that attach to the release of these records. So whether it's a vested,
Well, what do you mean by that?
sorry about that. So it's, strike that, I'm sorry, Your Honors. Why is this not a vested right? Excuse me.
Just to step
Yes,
back, maybe.
please.
It seems to me that Acevedo and Forti raised the question of whether or not, and I think this is how your adversary responds to those cases, whether or not the right to confidentiality in the, whether or not the prior statute conferred a right to confidentiality in these records that vested at the time that the records were created. Because if that's correct, then it may be that we have to go through and apply the retroactivity test to determine whether the legislature intended for this to be retroactive. And so what I'm trying to understand is in your brief, you argue that this is not a case of retroactivity at all, and we need not apply that framework. And so I'm trying to explore why it is that the analysis doesn't apply. I think it turns on whether it's a statutory privilege or a vested right, and so why would it not be a vested right?
Well, Your Honor, I mean, again, 50A, what we're talking about here is the Freedom of Information Law. And in the context here, Section 50A is merely applied as an exemption via 87(2)A in the Freedom of Information Law as an exemption to disclosure.
But I
So-
think that the argument would be that at the time the record is created, because the statute said it could not be disclosed absent court order, we'll set that to the side, or the express written consent of the officer, that creates a vested right that the officer holds in the permanent confidentiality of that record. And that's different than a statutory privilege that if you don't happen to invoke it while the statute is still in place, doesn't travel forward if it's then repealed. So I think that's what I'm trying to explore.
I understand. Well, Your Honor, even if one were to assume, just for the moment, that this were a vested right, the intent of the legislature here could not be clearer. There is no express statement of retroactivity in the law. We acknowledge that. But there's no requirement that particular words be used. And in some instances, retroactive intent can be discerned from the nature of the legislation. And this is exactly that type of legislation. Section 50A was repealed.
Is this the remedial argument? Is that what you're saying?
This is an argument just that even if one were to assume that this were a vested right, the pre-repeal records still should be disclosed because the very nature of the legislation was to shed light on
And my question
pre-existing
is,
records.
what is the nature, or what is it about this particular piece of legislation that indicates the legislature's intent that it be applied retroactively?
Well-
That's different than what we've said in a number of cases.
Yes, well, initially, Section 50 was repealed less than 3 weeks after George Floyd's murder. The entire purpose of Section 50A was to make the disciplinary records open to the public and thereby restore trust.
Let's take these, let's just slow down a little bit.
Yes.
So it was done 3 weeks after George Floyd's murder.
Yes.
How does that let us know that the legislature meant to produce or exempt from, remove the exemption for old records as opposed to going forward?
Yes. Well, so there are a number of things.
Why does that cut on that?
Well, so first of all, the legislative history is replete with references, including by the PBA itself, showing that the understanding was that by repealing Section 50A, all records would be made available.
All old records?
All old records, all records, period.
Well, old records, period, doesn't really distinguish between forthcoming and old,
Okay, well,
right? I mean, what is it you can point to directly, if anything, in the legislative history that shows the legislature intended
sure.
to require the production of pre-existing records?
Of course. So, for example, we cite a number of examples of legislators in the floor debates specifically calling out the history of the debate. So, for example, the bill's sponsor, Senator Bailey, this bill would repeal Section 50 of the Civil Rights Law, but add necessary privacy protections. Senator Gianaris.
Yeah, but that doesn't tell me forward or backwards.
Senator Gianaris, let us know who the people with a history of problems are so that we can work to improve the system. In the bill jacket, in the introducer's memorandum in support, Senator Bailey said police-involved killings by law enforcement officials who have had histories of misconduct complaints,
Yeah,
and in
but
some
even-
cases
even the word-
recommendations.
Yeah, even the word history there doesn't talk, that doesn't distinguish between a forthcoming history, that is your record, basically, history in that sense, and the past. I'm still not getting there.
Well,
Well, let me shift you a little bit to something else. It goes back a little bit to what Judge Halligan was asking about. So, the various state agencies have people's mental health records, and those are protected confidentially, right?
yes.
So suppose the protection for that was repealed. Would you say that there's no vested right there?
So
People's old mental health records should be produced if the exemption were removed?
I think that given if the legislature chose to repeal those provisions and made statements of legislative intent as clear as here, which we contend that they are, yes, those provisions would be repealed, but
So that really goes to your view that they intended this to be retroactive, not that this is not a vested right. Let me ask it
Correct.
more prospectively, right?
Okay.
Or not prospectively, but directly. Do you perceive a difference in whether somebody's mental health records constitute a vested right or somebody's police disciplinary records are a vested right? Is there a difference?
Well, Your Honor, I think first of all, in the context of police, well, yes, police officers are public servants, Your Honor. And, they're provided with vast authority to deprive people of liberty, in some cases, take people's lives. And yes, I think that as public servants, they're certainly differently situated than people in the situation that you just described. I don't know if did I answer your question, Your Honor?
You did.
Okay. Sufficiently?
Well, we'll see.
But I think that the key point here, though, is that at bottom, this case really presents a straightforward application of the FOIL statute. And as I mentioned before, as of June 12th, 2020, the FOIL statute ceased to exist, and there is no exemption that applies via the FOIL statute that is specifically exempted from disclosure by state or federal statute, which is the only exemption at issue here.
Is there any impact on the reasons for the creation of the legislation or the effect of the legislation if you exempt from disclosure those prior records?
Massively. It completely guts the legislation. Basically, let me put it this way, Your Honor. FOIL is inherently backward-looking. And so, by their nature, FOIL requests seek records that were generated prior to the request date. The PBA's interpretation here of the repeal would render it basically a nullity. Think of it in these terms, Your Honor. The petitioners filed 144 FOIL requests here, seeking officer disciplinary histories. All of them were made within a week of the repeal. Most of them were made the day the repeal was made. Under the PBA's reasoning, petitioners would have been entitled to 0 records. That's just so contrary to what the legislature intended, which was to increase transparency, to make these records open to the public, and to say that we were entitled to 0 records is kind of just makes the entire repeal.
Well, except today, if you made the request, you'd be entitled to 3 years of records, and 10 years from now, you get 13 years of records, and at some point, police officers retire, and it's not entirely nugatory, it's just a long phase-in.
Perhaps, but it does run in the face of the idea that this needed to be enacted immediately, which is in the text of the statute.
Well, shouldn't we demand that kind of language from the legislature if they're intending retroactive effect or some clear intent of what they want as opposed to having this discussion?
I think that if anyone lived through the period in 2020 during the protests that led up to the repeal following Mr. Floyd's death, I think that the intent was pretty clear. This is not some obscure law.
Wouldn't it be more clear if you had put the words in the statute? This applies to all records that existed at any time before enactment of this statute?
Well, Your Honor, I would say 2 things to that. One, the text of the law, the repeal wasn't made in isolation. It was part of a broader package of FOIL amendments. Specifically, it added Section 86.6 to FOIL, the definition for law enforcement disciplinary records, which includes any records created in furtherance of a law enforcement disciplinary proceeding. It also defined various other terms using this broad term, any. And so, in none of these provisions does it say any record hereafter created or that records created before the effective date were excluded. It said any record. And the legislature, if they wanted to carve out this period from 1976 to June 2020, they easily could have done that, but they didn't do that. With respect to the point that you just raised about the words used, this court in the Regina case in 2020 said there's no requirement that particular words be used, and in some instances, the retroactive intent can be discerned from the nature of the legislation. And the nature of this legislation was to shine a light on police disciplinary records and police misconduct, and to try and increase trust and accountability between the people and the public, but between the people and the police force. I see my time has expired, but thank you. Thank you.
I'll just spend a moment on the vested rights issue, and then I'd like to turn to the retroactivity
Counsel,
analysis.
before you go to the vested rights, 50A operated as an exemption to FOIL, correct?
Not exclusively. It operated independently of FOIL. And so what this court said in a case in 2018 is even if the agency wanted to make redactions to the records to remove names and things like that, 50A, so the FOIL exemptions say they're discretionary, including the one that they rely on. What this court said is 50A is an independent mandatory statute, so there is no discretion for the
Okay,
agency.
so now that 50A is gone, what keeps the old records out of the hands of those who request them?
And just to add one more point to that, you are correct in what you've said already about the statute, but the statute itself recognizes exemptions by statute. Once the statute is repealed, you no longer have the statutory basis for the exemption under FOIL.
But I would submit that even without that exemption within FOIL, 50A would have said, these records are confidential, you can't produce them. There'd be some kind of conflict with the statutes there. But to answer Your Honor's question, the retroactivity analysis is what keeps the rights preserved. Whenever there's a change in the law, if somebody makes an argument that, hey, this is prejudicing our rights that previously existed, the task of the court is engage in a retroactivity analysis. And if there's an impact on pre-existing rights, then unless the legislature makes a clear expression of legislative intent, otherwise those rights continue.
Well, why isn't the urgency with which this was enacted and the circumstances surrounding it in the direction that it take effect immediately, why isn't that enough of an indication?
So when this court has talked about urgency, what I think this court has been talking about is urgency in response to some court decision. That's what the remedial doctrine is all about. If you look at how this court has...
I'm not asking about remedial doctrine. I'm asking, right, we can infer, we don't need the legislature to say this is going to operate retroactively. I think we've been clear that we don't have to use words like that, and that it can be inferred from other circumstances. Would you agree at least with that proposition?
Your Honor, I think we should be more specific with the test that this court has set forth. It won't apply retroactively unless the language expressly or by necessary implication requires it. That's Majewski, that's Gottwald, that's King. So it's not just, is there enough here for us to draw some kind of inference that maybe this is what the legislature intended?
What about remediation? What about the view that the legislature did what it did in this amendment because it perceived a misbalancing in the rights that was affected by 50A that had to be corrected, and using that as a basis for saying it must be retroactive because they saw a misapplication, a misbalancing of the right between the public to know and the officer to have confidentiality?
The issue is that there's nothing in this legislative record where the legislature made this balancing and said, in order for these policy interests to be served, we need the pre-repeal records to be disclosed. If they had said that, fine, and that's all we're asking the court to do.
Well, that's true, we wouldn't be here, but the question is really, are there other circumstances that would lead one to say you can't give the full, robust effectiveness of the statute without also letting it apply to previously created documents?
So that's the necessary implication standard,
Correct.
Your Honor. And the
Correct.
way the court has applied that standard is when the statute, when the change would become ineffective or superfluous without retroactivity. And that's not the case here by any...
Why not? Why not?
Because records post-repeal that otherwise would have been continued to be protected are now subject to disclosure. That's a big policy change in New York
Sure,
City.
that's a good thing, but that's not answering the question. The question is whether or not all those records before the effective date of the repeal that are already created would also be necessary to furthering the goal of that repeal.
Well, so
And a FOIL.
So you're not saying the statute would become superfluous. What you're getting to there is, well, perhaps some could say the policy interests maybe are better served by allowing pre-repeal records to be disclosed.
Not some, that's what the legislature
They didn't say,
intended,
they
right?
did not say that, Your
No,
Honor.
I know, that's why it's called implication. I understand that.
I would submit that there's nothing even to make that, to imply that, but I think
Okay.
what
So
the,
protests in the streets, across the country, including in New York?
That's what
That
led to
send
the
a message
repeal.
that moves the legislature faster than perhaps it's moved in quite some time?
The legislature certainly acted quickly. I think the speed with which the legislature acted works in our favor because they said, we need to get this repeal in place so that records can start being disclosed to the extent
But
that incidents
you
occur.
You sort of have two possible views of what the legislature might have done by acting really quickly, right, or done through the statute. One is that they said, there's a real problem here, and we want to make all these records available so the problem can be addressed day one. Or you might say, the legislature said, we would like to start making records available so that as there's new police officers hired and police officers retire, we'll start building up a record. And so 20 years from now or 25 years from now, we'll have a complete data set from which we can do this sort of thing. And you're sort of choosing between which of those things do you think the legislature meant?
And I think the problem here is that we're just stuck with a very, at best, ambiguous record, and policy arguments can be made on both sides. There are policy arguments for disclosure, but there's also policy arguments to protect rights, because you had officers who relied
Your red
on...
light is on, so I just wanted to ask you to be a little bit clearer about what is the reliance, what is the expectation, and how that, where I can find that in the record. I know you've already given some citation, but what is it? Did they change, did the officers change some conduct, make a decision based on this expectation that you can point to?
Well, yes, so the record site is the one that I gave you, but I'll give you the best example, and this
Yes,
comes from
yes.
that record site. So you have an innocent officer who's had a meritless complaint asserted against him. To fight a disciplinary complaint, it takes resources, it takes time, it distracts the officer from his job. Section 50A promised that officer confidentiality. So instead of taking the time, the burden to fight the charge, the officer said, this is going to be confidential anyway. I'm just going to settle this charge. I'm not going to fight it because the record is subject to protection. Without section...
With the understanding that a court might in the future
If
order
it's relevant
access,
to
right?
a pending
It's not-
action.
It's not that it's hermetically sealed and no one will ever see it.
Yeah, there are exceptions under 50A, but without 50A...
But if you make that choice, as you've just described it, with the understanding that a court might order it, why is it so far afield that one might not say, and then this exemption might be extinguished in the future?
I'm just answering your question, Your Honor, in terms of reality of what happened. This is what happened on the ground. If 50A had not been in place, officer would have fought the charge, innocent officer wouldn't have this on the record. The officer settled the case, conceded to liability. Now, years later, the state is taking away the confidentiality that was promised to the officer, but the officer...
What about the reliance of the not-so-innocent officer? Who
Well,
wants to use it as a shield so that no one knows about their bad acts?
Well, that's why the legislature repealed this on a
Yeah,
prospective
but that's
basis,
the point
Your
of
Honor.
well, but in the past.
Nobody
Right? We're
said...
talking about the I'm asking you about reliance.
Well,
Should we honor the reliance of the bad actor once you use it as a shield?
The retroactivity analysis is not done on an officer-by-officer basis. The retroactivity analysis depends on, was there a right granted, and has that right now been taken away? I think there's no question that there was a right granted that's now...
Just on that point, I know your light's on, but just very quickly, our vested rights cases say that vested rights are what we have called dangerous and that we should exercise great caution. So my question for you is, what other statutory provisions can you point to that are like this, that have created a vested right such that there's a question of retroactive application?
It's a good question, Your Honor, and this is an issue of first impression in New York. Do confidentiality...
No, I know, but I mean, what other statutory provisions outside of this context have created vested rights? The reason I'm asking is if our cases say that it's something that we should be very cautious about, a label we should be very cautious about applying, where else have we done that, what you're asking us to do here?
The best that I can do to answer your question, Your Honor, is to point you to the Supreme Court of Utah, which...
But not under our cases. Are there other cases that you would point us to where we have a statutory provision and that statutory provision creates what we decide is a vested right such that the retroactivity analysis is triggered? Because I haven't found them, that's why I'm asking.
Well, the frontier... Are you just asking in any context has the court
Yes.
applied a vested right? So
Not this particular context, other contexts.
this court the vested rights concept has not been significantly addressed by this court. And I do think that this is an issue of first impression for the court, but other state courts, and you'll see this in our brief, have said confidentiality rights are vested rights. And I just want to leave the court with the question of how dangerous it would be for this court to say in this case, well, confidentiality rights and privacy rights are not rights that are subject to the presumption against retroactivity, because I think that's where your questioning would be leading to say this is not a vested right. We don't even have to engage in the retroactivity analysis. Why should confidentiality and privacy rights be second-class rights that
Does
people
it
are...
matter what you're trying to hold confidential? The example given previously by the chief judge, medical records versus disciplinary records?
I think what's important is that people rely on confidentiality. So when you have a case like this that's promising confidentiality and you have people fashioning their behavior based on that, to then take that away after the fact has an unfairness that the retroactive doctrine is meant to prevent. And I don't think there's any reason to treat these rights differently than other statutory rights. Thank you, Your Honors.